Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Um, just got back from a fantastic vacation from France, Belgium, Germany, Holland, ready to get back to it. What I'd like to talk about today is called acquisition of citizenship. And while this may seem to be a foreign word to you, the reality is sometimes people will come to the U.S., they'll be born somewhere else, obviously. That's the first key, is that for acquisition of citizenship, you must have been born outside the United States. But sometimes people will either be in removal proceedings, they'll be senior citizens, they'll have already been deported. You never know when the issues will pop up that will actually lead to the conclusion that in fact you might be a U.S. citizen and not know it. That's why whenever I'm giving a consultation in the initial intake sheet, I will always ask, where were your parents born? Where were your grandparents born on your mother's side? Where were your grandparents born on your father's side? Did your parents or either one of them ever become a U.S. citizen? If so, how old were you at the time? Just different questions like that, so I can ferret out whether or not there's an acquisition of citizenship issue which might occur. And I can tell you that people come in all the time with different issues. They say they can't get their green cards, they're in removal proceedings, they've already been deported, their family wants to know how to bring them back. And in maybe 1 out of 20 cases, give or take, there's a possibility of acquisition of citizenship, which nobody saw. And once I delve into it, there's been several cases that fortunately I've been able to put through where the person was in fact under the law a U.S. citizen and they didn't know it, and voila, they were, proceedings were terminated, they were allowed to come back, so forth. So it's not something that, while I would say occurs every other day, it is also not something that should be disregarded as, for example, winning the lottery. I mean, there is a reasonable possibility under certain circumstances that it might exist, and that's why it always has to be looked into. So let me give you, while there's different situations that would arise as to whether or not someone is a U.S. citizen, I'd like to concentrate on a couple provisions of the Immigration and Nationality Act. Now, what you also have to realize when doing an analysis for acquisition of citizenship, unlike other areas of law, is let me tell you the majority of how other areas of law and immigration goes. While of course there's exceptions, generally speaking, the law as it stands today is essentially the law that you would have to follow. But with acquisition of citizenship, the law that was in effect at the time of the event that would have made you a U.S. citizen is what needs to be followed. So, for example, somebody born in 1960 would most likely have to have analyzed a different area or different section or a former section of law as opposed to someone born in 1986. Okay, so that's why it's necessary to do the proper analyzation in the first place with the proper timing of the statutes to determine if it applies to you. But I'd like to, for argument's sake, just go over a couple of provisions and of the Immigration and Nationality Act and how it might apply to you. And if you think that you know somebody or it might affect you, you let me know. Give my office a call. I'll give you a free consultation, let you know what can be done, and then we'll go from there. So the first section is Section 320 of the Immigration and Nationality Act. And this specifically applies to children who are born outside the U.S. and are currently residing inside the U.S. And it is a condition or the law which mandate when citizenship will be automatically acquired. So this is a great provision. This is the provision that if it applies, it doesn't matter if you applied for anything, it doesn't matter if you didn't apply or did or whatever, you're automatically a U.S. citizen at the time that this would have occurred. Okay, um, and so while the next provision I'm going to be talking about will be Section 322, you always want to try to get under Section 320 because it's automatic if it applies. But if you can't get under 320, then you jump down to 322 and maybe that'll be applicable as well. So let's go over the provisions. First of all, a child needs to be born outside the United States. Obviously, if the child's born inside the United States, we must analyze a different section, and for the most part, they will be a U.S. citizen as well. But I'm concentrating on those children born outside the United States. So, what are the conditions that need to be fulfilled in order for Section 320 to apply? One, at least, and this is as the law applies today. Okay, if we go prior to 2001 and then again prior to 86 and so forth, there's different analysis that needs to be done. But again, I'm not going to analyze all the different sections right now. I'm just going to show you how it applies today so you can get an idea of what it is. Okay, so first item is that at least one parent of this child must be a U.S. citizen. And it can be, this person, the parent, can be a U.S. citizen by naturalization or by birth. Okay? So, first look and see if the father is a U.S. citizen or see if the mother's a U.S. citizen. And the child was born outside the U.S. Then, again, it doesn't have to be just a mother or father that was born in the U.S., which, for the most part would make them a U.S. citizen. It could be a mother or father that was born in the Philippines, in Europe, whatever it is. They came to the U.S. on a green card. They later did what they had to do and ultimately became a naturalized U.S. citizen. Either way will work. Okay, second, the child is under the age of 18 years. Now, it doesn't mean that, for example, let's say you're the child, except you're not a child anymore. Let's say you're 45 years old and you're in removal proceedings and they're trying to deport you, and I'm questioning you about this stuff, and sure enough, let's say the first two elements were met. Okay, let's say that you were obviously not born inside the U.S., that your mother became a citizen, a U.S. citizen prior, or became a U.S. citizen, let's say through naturalization, and let's say that she became a naturalized U.S. citizen when you were 17 years, 3 months, and 22 days. Okay, so far so good. Everything is meeting. So what's the final element that's necessary? Well, the child residing in the U.S. is in the legal and physical custody of the citizen parent pursuant to lawful admission for permanent residence. So what does that mean? Usually when I do analysis on these type of cases, this is the one that usually is the hairy one. This means that you will have to show that you are in the lawful, physical, and legal custody of that particular parent. Okay, so if, for example, the mother became a U.S. citizen before you were 18, and let's just say that you didn't live with the mother. Let's say you lived with the father, okay? And let's say the father wasn't ever a U.S. citizen. Well, that kicks you out of this provision. It's just not going to work. Or let's say that the father became a U.S. citizen before you turned 18, but the mother became a U.S. citizen after, let's say when you were 19, and let's say that they were divorced, okay, and that you lived with the mother, not the father. Well, in that case, it won't work. But let's say you lived between both, joint custody. Let's say that they were divorced and you went from the mother to the father to the mother to the father. Well, then there's a reasonable argument that you do fall under this section. So I'm just throwing these different scenarios out at you because there's all kinds of little threads that can go through an analysis. So for the most part, just keep the following in mind. And then, if you think that you might fall under this particular category, give me a call. You were born outside the U.S. At least one parent was a U.S. citizen by birth or naturalization prior to when you turned 18, and that you are residing in the physical and legal custody of the citizen parent pursuant to lawful admission for permanent residence, which means, of course, that you had to get your green card. You have to have your green card. Okay, so if you have all those and you're fighting your case, or you're just trying to get a green card right now, or renewed, or for example, you committed some crime that now makes you inadmissible, again, you might look under this particular section. So what's the next section that you want to look at? Well, the next section is Section 322 of the Immigration and Nationality Act. And in this particular one, this is sort of a fallback analysis. Okay, this is when you don't fall under 320. Remember, all is not lost. You might be able to get under 322. So, for analysis point of view, you don't want to go first to 322 and then see if you qualify for 320. Do it the other way around. So Section 322 is for children, again, born and residing outside the United States, okay, and is under certain circumstances when they will acquire citizenship. So, in general, a parent who is a U.S. citizen of the United States, or if the citizen parent died during the preceding 5 years, you can use the citizen grandparent or legal guardian. Okay, they may be able to substitute for the parent in this particular case. They can apply for naturalization on behalf of the child born outside the United States who has not acquired citizenship automatically under the prior section. So that's the first big change here, minus the fact you can also use the grandparent, is that they must make an affirmative application for naturalization on your behalf rather than you automatically acquiring it. The other one, you're automatically a U.S. citizen. Now, whether or not the government knows about it and whether or not you can come in and out of the U.S. with a U.S. passport is a different thing. But you don't, realistically, you don't ever have to actually apply for anything in order to get it. With this one, there must be an application on the child's behalf for naturalization. Okay, so what are the conditions that apply in order for this to be approved? Well, again, and let me preface this by this is the law as it stands today. Section 322 had different provisions, different requirements, depending on when it was enacted or reenacted or updated. Okay, but the first is that at least one parent, or with the proviso, the grandparent and or guardian, if they died within 5 years, is a citizen of the U.S. Either by birth or naturalization. So again, they can either be they were born here or they became a U.S. citizen. Now, the U.S. citizen parent, okay, so listen carefully here, the U.S. citizen parent has or had been physically present in the U.S. or its outlying possessions, so like America, Samoa, Puerto Rico, so forth, for a period totaling not less than 5 years, of at least 2 which were after attaining the age of 14. Okay, so unlike the prior Section 320, there is a physical presence requirement here in order for this to occur. So we have to analyze when the parent was in the U.S. and for how long and at what age. Okay, so given that, the physical presence requirement sometimes is hard to obtain because, for example, some cases the parent has died. But if that's the case, you can go to IRS, and usually the child can get the records from IRS from a parent who has died. Now, all of this had to occur prior to when the child was 18 years old. So keep in mind, again, that the physical presence of 5 years, 2 must be when the parent was over 14. So let's say that the parent lived in the U.S. from ages 0 to 5, or even 0 to 10. That won't qualify. You need to have 2 years after the child was 14 in order to qualify. Okay. Now, the A child again is 18 years old, and here the next requirement is that the child is residing outside the United States in the legal and physical custody of the applicant. Or, again, if the parent is deceased, an individual who does not object to the application, being a grandparent and or guardian. So, in this particular case, again, the child, if we look at the differences between 320 and 322, in 322, the child is outside the United States. The child has not been admitted as a lawful permanent resident, and the child does not have the green card. Okay. Now, in this particular case, that would be the third element. Now, the fourth element is the child then is temporarily present in the U.S. pursuant to a lawful admission and is maintaining such lawful admission. So a lot of times I'll get these cases, the child will be outside the United States. I'll then petition to get the child here on, for example, a B2, a visitor visa, so that then the moment they get in, we can apply for Section 322 acquisition of citizenship, assuming all else is met, because they have to be in legal status. Let's say the child is here illegally and has been illegally for 20 years. Or for 5 years, whatever it is. We can do a advanced parole or humanitarian parole to allow the child to leave, come back, again, be lawfully admitted, and in legal status for the purpose of applying for acquisition of citizenship. There's all kinds of ways. So in this particular case, and in Section 320, it will also apply to an adopted child, assuming they were adopted properly under the age of 16 and it was final prior to that time. So in this case, as you can see, there are lots of different scenarios as to when a child may or may not fall under 320 or 322, and if it all applies, then that person can become a U.S. citizen. So it's a great area of law a lot of people don't know about, which is, it's amazing when it works because, again, somebody is in, I've had cases where people were going to be deported for the rest of their lives without any chance of coming back, only to find out that they were a U.S. citizen. So those are nice, happy endings. So if you like the video, click like, click subscribe, and give me a call and or email me for a free consultation, and then we'll go from there. More in the coming videos.